changing the play at the line of scrimmage. This is something quarterbacks are often evaluated on, their ability to call an audible and change the play that was otherwise planned differently to adapt to changing circumstances. But few people consider that in the context of estate planning. However, with the creation of the portability election, along with other elections that existed prior to portability, such as the disclaimer and the Q-tip election, you can create an estate plan that allows an audible to be called, or multiple audibles, be it by the surviving spouse, or by the personal representative, or both. This can prevent the traditional rigid estate plan that locks in the family to a credit shelter trust structure, while also giving a few better options maybe for investment planning within the estate and resulting trusts. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. For today's episode 162, it's titled Portability Planning, Calling an Audible. As always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. And if you'd like a copy of these slides, please email me at griffin.bridgers@gmail.com. So, prior to portability, a huge discussion revolved around the estate tax inefficiency of overfunding a marital bequest or marital deduction. And that was common in the most basic form of estate plan for a married couple, which was known as the sweetheart plan, where typically you would just leave everything to the survivor at first death and then to the children at second death. Now, beyond the estate tax inefficiencies in that, it also failed to plan for second marriages or remarriage by the spouse and a variety of other things. So, with that, we've evolved into a trust structure using a marital trust that may preserve some of that protection, but getting back to the overfunding issue, whether or not you're creating a marital trust or not, before portability, overfunding a marital bequest meant that the unused estate tax exclusion of the first spouse to die was lost. However, with the portability election, this takes some of the risk out of an overfunded marital bequest to allow for a preservation of the first spouse's unused exclusion. But even prior to the portability election, there were options that allowed for the spouse or personal representative to change the flow of the estate. The good news is we have 3 outs, or maybe even 4 if you consider a subcategory of audible we're going to look at, where with a properly drafted estate plan, you can maximize the flexibility and the choices here that might be available at first death. So here's the basic plan design we're going to look at. We'll have the decedent's estate, and at first death, by will or beneficiary designation or otherwise, we primarily fund a marital trust, where the spouse is the sole beneficiary, or we could even leave assets outright to the spouse. That may not be a good idea in a second marriage or remarriage scenario, but aside from that, what we're focused on is the fact that within that marital trust, there are certain audibles that can be called. One may be to optionally fund a credit shelter trust by disclaimer or Clayton Q-tip election, with the difference being that any assets going into that credit shelter trust will use the estate tax exclusion of the first spouse to die. And then, at second death, the combined value of that marital trust, and, if any, the credit shelter trust, and then finally, the surviving spouse's own individually owned assets, will be divided into equal shares for children and may be held in trust for them until a certain age or for their lifetime or whatever the case might be. But the big picture item here is that anything in the marital trust, or anything that's part of a marital bequest, subject to certain elections, will either be taxed in the estate of the first spouse to die, which will use the estate tax exclusion of the first spouse, or it'll be taxed in the estate of the second spouse to die. And typically that would be the case with the marital deduction, which simply defers estate tax until the surviving spouse's death. So with this said, this is the sweetheart plan, but with an optional marital trust and credit shelter trust thrown in. And as I mentioned, the marital trust aside from estate tax, is a good idea to protect against remarriage or second marriage situations because it allows the first spouse to die to lock in advance the remainder beneficiaries of that marital trust. So it keeps the spouse from preferentially providing for maybe their own children or down the road remarrying and providing for new children or stepchildren through that marital trust vehicle. But you have to set this up as a Q-tip type marital trust, qualified terminable interest property trust. We've covered that in prior episodes, but the big picture there is that you cannot give the spouse a general power of appointment if you want to preserve this maximum flexibility. So assuming you have that maximum flexibility there with a Q-tip marital trust, then here are the three audibles that can be called. One is a disclaimer, where the spouse could disclaim assets to a contingent credit shelter trust, and typically with a disclaimer you have to give up your interest in the disclaimed assets, but in this case the spouse can disclaim to a credit shelter trust and still be a beneficiary of that trust. The only catch is that the spouse cannot hold a power of appointment over that credit shelter trust. Another audible is the partial Q-tip election. So you can choose what part of the marital trust will be taxed in the estate of the first spouse to die and what part will be taxed in the estate of the second spouse to die. So that partial Q-tip election can be used to preserve unused estate tax exclusion, in addition to that disclaimer that we talked about above. The big difference here is that we have maybe another subcategory where either those assets would stay in a marital trust for the sole benefit of the surviving spouse, or you could make a sub-election here called the Clayton Q-tip election, which would look at whatever portion of the marital trust for which no Q-tip election was made and maybe administer that instead under the terms of that contingent credit shelter trust. The difference being that with the marital trust, only the spouse can benefit, but with the credit shelter trust, both the spouse and descendants, like children and grandchildren, can all benefit from a common trust. Then finally, the third audible here is the portability election, where to what extent there's any exclusion left over and there's any overfunding, that unused exclusion could be preserved. So we have three audibles here and maybe even one sub-audible with the Clayton Q-tip election. Now, that being said, these audibles are not exclusive. They can be used in any combination, with the caveat that there is no partial Q-tip election available if there is an outright marital bequest to the spouse. So if you want maximum flexibility here, you have to fund a marital trust. Now, with the disclaimer, that's an election always made by the spouse. So the spouse has 9 months from the date of the first spouse's death to make that election, but the caveat is that they can't benefit from the marital trust during that time. So the disclaimer election may not always be optimal in this type of scenario, but it's at least an option there. But the other two elections lie in the authority and discretion of the personal representative. So the personal representative would make either the Q-tip election or the portability election, or both, on an estate tax return, Form 706. And one drives the other. The portability election will largely be dependent on the Q-tip election, because the more that goes into a marital Q-tip trust and defers estate tax through the marital deduction, the more unused exclusion has to be preserved through the portability election. Now, there are many benefits here, and by no means can we capture them all, but this creates a more flexible estate plan, which doesn't lock the family into a credit shelter trust. And it may be easier to administer, especially for a zero tax estate, depending on which audibles are called. Now, if the portability election is made, you do have to file an estate tax return, Form 706. Which you'd also have to file anyway for that partial Q-tip election. But in the case of the portability election, there may be simplified reporting available on the 706 for whatever portion goes to a marital bequest or an elected Q-tip marital trust. And if you just have a marital trust here, there may be less potential for conflict between the spouse and beneficiaries when you look at a marital trust versus a credit shelter trust, because the marital trust can be administered for the sole benefit of the spouse and the trustee has relaxed duties in terms of preserving principal for the remainder beneficiaries when compared to a credit shelter trust. Then finally, if there's no estate tax at second death, this creates a double step up in basis. For one, all assets get a step up in basis at first death, and second, anything that's in the marital trust for which a Q-tip election is made gets a step up in basis at second death as well. So there's some income tax benefit that double dips there as well. Now, this plan is not without its issues, the biggest being that the portability election does not preserve the deceased spouse's unused GST exemption, but the disclaimer and or partial Q-tip election would. So those may be better options in a situation where there's GST exemption that could be wasted. Also, that estimation of value simplified reporting for marital Q-tip assets on the 706 has to be in increments of $250,000, which is inefficient and does not establish basis for those assets. So that creates an additional reporting obligation. Another issue is that if anything stays in the marital trust, the children can't benefit from the marital trust until the surviving spouse's death. And their benefit is subject to depletion and static growth because that trust will often be invested for income. And not only that, if the spouse wanted to benefit children, they could have gift tax if marital trust assets are used to make transfers to the children. And you lose that double step up in basis for the credit shelter trust assets as well. Not only that, if the credit shelter trust is funded through a disclaimer, the spouse cannot appoint those assets. So it lessens the flexibility there if, for example, you have a child with special needs or some issues that may require its own audible within the plan through a power of appointment. So this is a very flexible plan, and the takeaways are that this works well now, especially for a couple who is not likely to have an estate tax liability when you look at their combined estate tax exclusion amounts today. But in the future, this may not work as well if the exclusion is reduced, especially if the GST tax exemption is reduced. And with that being said, GST tax planning, especially if there's GRATs involved, may demand a more traditional AB type of plan structure where you fund first a credit shelter trust up to the remaining exclusion amount and maybe an optional GST exempt credit shelter or marital trust to the extent of unused GST exemption if greater. And one other issue is to be considering the marital issues. In a second marriage scenario or remarriage scenario, you have to be careful how this is drafted in terms of the marital trust, and maybe if you give a limited power of appointment to a spouse under that marital trust, who can benefit from it. And with that being said, the audibles may not be tax driven. You're considering the marriage options, but also looking to how you fund each trust. You may consider funding the credit shelter trust with illiquid growth assets like real estate or closely held business interests, or looking at income producing assets going to the marital bequest. And this is important because a spouse has the right to demand that marital trust assets be made productive. So a spouse could force a sale of those illiquid growth assets. And if you want them to be preserved for second generation and for your children, it's important to have a vehicle to make sure that happens without a forced sale by the spouse. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.